We received a couple of, good morning, we received a couple of counter proposals from you this morning.
Why don't we take care of a couple of housekeeping matters first?
Yeah, that's what I was going to suggest.
We sent a couple of bargaining extension agreements. The
Okay.
current bargaining period ends on June the 19th. That would extend us through July the 19th.
Right.
If y'all are agreeable.
Yes, in fact, I have printed them out.
Okay.
The only change I made was to reflect the number right here.
Oh,
This just
okay.
said 2, so I just fixed it to reflect bargaining extension agreement number 5, which would take us to July 4th, 2015. That's a 15-day increment. And then agreement number 6, which would take us to July 19th, 2015.
Right, yeah, I just overlooked that.
Today's June, right? Okay, June. And that would allow us to schedule the sessions that we're looking at scheduling.
Mhm.
We currently are looking to confirm those. We are definitely confirmed for June 24th. I already have the facility booked. And we will be posting the public notice. The other ones that we're looking at are July 6th through 8th, July 13th and 14th, and July 16th through 17th. And I'm very confident that those will work.
Okay.
With the exception on July 6th, I might have a conflict in the afternoon that may take an hour or two.
Okay. And those 4 days in that last week, the 13th, 14th, and I think the 16th, 17th, I don't know that we'll necessarily need or want all 4 of those, but I was just telling you those are dates that I have available.
Okay. We'll see what works best. I know that we do have a council meeting on the 14th, which is July 14th, which is a Tuesday. We don't on July 7th, but I need to look and see what I can anticipate would be on the agenda, just to make sure that I have a quorum on that day.
Okay.
See where you've been on this.
We're not meeting tomorrow,
How much do we do? So do you want to discuss your proposal
Sure.
on EMS?
Let's go ahead and do that. Pull it up real quick. Okay. Our counter proposal is to your last counter proposal for May 19th at 9 a.m. and it's on Article 33, Emergency Medical Services. We have made a lot of movement in accepting a lot of the language that you have proposed with regards to grandfathering people in. What we're looking to do is pursuant to, on the grandfathering issue, is to maintain the status quo of what the contract provides, the old contract provides, with the purpose and goal of any new hires that are coming in to be required to be certified paramedics throughout their tenure as a condition of employment, and
You're looking at that section 1D.
right. And so let's go through it. On section 1A, we're talking about firefighters hired on or after May 31st, 1985. We've accepted all of your language there because and the intention is we believe that it maintains the status quo of what the contract provides. Firefighters hired on or before May 31st, 1985 need not maintain a paramedic or emergency medical technician certification. Firefighters hired on or before May May 31st, 1985, who voluntarily obtained a paramedic or EMT certification and thereafter promoted to firefighter 2 EMS must maintain their certification while remaining in the firefighter 2 EMS rank. However, they may allow their certification to lapse if promoted to firefighter 2 driver or above.
Okay.
Number 3, after 5 years of continuous ambulance service, firefighters hired on or before May 31st, 1985 may, upon request, voluntarily demote from firefighter 2 EMS to firefighter 1 and will no longer be used for ambulance duty. Therefore, they may not be required to maintain their paramedic or EMT certification. And by accepting all this, in no way do we ever intend to, if somebody who falls within this category still maintains their paramedic certification and still rides the ambulance because they want to, we don't want to dissuade them from doing that, okay? This is just, we're providing that minimum for them there. On section B, firefighters hired between June 1st, 1985 and December 31st, 2005. Firefighters hired between those 2 dates must obtain paramedic certification within 18 months of the date of employment as a condition of employment. Absent mitigating circumstances, failure to obtain paramedic certification within 18 months shall constitute grounds for discharge. Number 2, firefighters must maintain paramedic certification for a minimum of 8 full years as a condition of employment. A firefighter who loses paramedic certification prior to the completion of the 8-year requirement will be granted 12 calendar months from the date he or she loses certification to regain that paramedic certification. Any time period without certification will not count towards the minimum 8 full year requirement, and absent mitigating circumstances, failure to recertify within 12 months after losing certification shall constitute grounds for discharge.
Okay. That's prior to the time that they've made the 8 full year commitment.
Yes.
Okay.
Yeah, and this is talking about that minimum 8 full year. Now,
Right.
please, even though this is a minimum, it says that they must maintain it for a minimum, it doesn't provide a maximum. So they want to keep it, there's no,
Oh, yeah.
there's no,
I got that.
you don't want to
Dissuade them.
from keeping it. In fact, it serves, it's for the benefit of everybody that they do keep it. Number 3 and number 4, let's see. Number 3, let's talk about number 3. I deleted that, and let me tell you what I deleted. It's that after 8 years of continuous ambulance service, firefighters may, upon request, voluntarily demote from firefighter 2 EMS to firefighter 1 and will no longer be used for ambulance duty. Now, this wasn't specifically in the contract, in the old contract, okay? But it's something that when it was not a detriment to operations, it was a request that had been considered and granted at certain times, or had been granted by the fire chiefs previously. The deletion of that doesn't mean that there's no ability for a firefighter under this particular section to be able to request that from the fire chief. It doesn't say that the fire chief will not consider it. It just has to be up to the where the operations stand, and that way it's not a detriment to the operations. Because if we leave this in there, it may cause a staffing problem with regard to who can ride ambulance duty, because this opens it up to a much broader group of people that if they were to request voluntarily demotion, to voluntarily demote to get off of the ambulance duty, the chief would be obligated to do it through the contract. And that's not the way it stands right now. It doesn't prevent that from being requested and being considered. And as you have seen previously through the history, when it was a reasonable request, it was always reasonably granted. And with staffing, the academies coming in and staffing being addressed the way it is, it may be something that would go back to the way it used to be.
Mm-hmm. Okay.
Okay? And then number 4, firefighters who have maintained paramedic certification for 8 full years are not thereafter required to maintain paramedic or EMT certification. Was that, on number 4, I was a little bit confused about that statement. Was that something that was already in the contract?
I was looking at that myself.
Because on page 19, and I crossed it out just because I really did have a question about it. Our intention is to maintain whatever the old contracts stated with regard to grandfathering. So if this is true, then that's something that we wouldn't have any heartburn about leaving in.
Okay.
The only thing I specifically found was on page 19, under section 2, that second paragraph, it says, all firefighters hired on or after January 1st, 2006 must maintain certification level of EMT basic or higher while employed in the fire department. Failure to maintain said certification shall result in termination. But if, I couldn't find anything that specifically said that the others, even though that's the way it may be that the others did not have to, were not required to do that. So anyway, what I'm basically saying is the intent is
yeah.
to maintain
Status quo.
the status quo is provided by the old contract.
You know, I think that the implication of the language, if you look at page 18, that first paragraph, it says, must maintain paramedic certification for a minimum of 8 full years as a condition of employment. Failure to maintain said certification shall result in termination. And you go over to section 2 on page 19, hired after May, and may be required to serve a minimum of 5 years in the EMS during the 8-year period of paramedic certification requirement. So we've always understood that to be that you can be required only 8 years as a condition of employment. After that, that requirement lapses.
Oh,
And
but that was for paramedic. What we're talking about here is just the EMT.
Oh, the EMT.
Well, okay, I understand the paramedic, but I'm talking about just the basic EMT because that number 4 on your proposal implicates not only paramedic, but any EMT certification, which can be basic or intermediate. And that's, I guess that's what really was confusing me.
And if you look at the second paragraph of section 2 on page 19, it makes a distinction. Firefighters hired on or after January 1, 2006 must maintain certification at the level of EMT basic or higher while employed in the fire department. So, in other words,
So that's when that requirement starts.
Yeah,
Okay.
that, so.
And I just wanted to have that conversation because, and I believe that's the way that I believe that, for firefighters hired after or before January 1st, 2006, so up to that December 31st, 2005, then once they fulfill their 8-year requirements, they're not required to maintain the paramedic and or EMT certification. And again, we don't want to dissuade anybody from keeping it, but okay. As long as, I'm gonna look at it again, but, look, if that is, I believe that number 4 should be okay, leaving it in there.
Okay. Okay. So we're on section 1C.
C, yeah, on there, I think that's the, I think we're trying to include the class in here, and you're trying to include these requirements for the class thereafter this current academy. And I understand your concerns on the notification. We're looking at that. So that's why I just kept it open, because it's an ongoing issue that we're looking at. But that's the reason that I moved it back. It would cover them. What we did do, okay. This is a grandfather also. And it would require the minimum 8 full years for the paramedic certification. And again, we took out number 3, which is the voluntary demotion, because that's something that may be requested, may be considered by the chief, but currently it's a management right, and due to whatever the operations need, if it's not detrimental, it's something that he would most likely not reasonably, withhold, but, that's up to a management decision is, as of right now. On number 4, then this is, this is,
Yeah, this is that,
the
well, I
other
was just
one.
reading, yeah,
Okay.
existing.
On D, again, the date, October 1st, 2014, we changed it to 2014 because of that ongoing issue with the current academy right now. But I think we both agree that, determining on what date we land on, but anybody from here on after, once we establish that date, would be required to maintain their paramedic certification as a condition of employment throughout the tenure.
Yeah, and our concern there is that the, and I know you just alluded to it, is that, the job announcement that they responded to contained the 8-year requirements
Right.
in it.
It said a minimum of 8 years, so I need to look at that to see what it looks like. Again, it doesn't have a maximum, but it says they may be required to do it a minimum. I think the word may is in there, so that may give us a little bit of wiggle room, but, I do understand your concern. We are
Yeah.
looking at it.
Okay.
We don't, we're not in the business of misrepresenting things, but that's the way it was set out. We wanna make sure everybody understands it, and, and what we're trying to accomplish is we're trying to, accomplish our goal of getting, all of our department being paramedic certified, throughout their employment with the, city fire department.
Okay.
We've agreed to all that green language, section 2, section 3, section 4. And then we took out section 5, special provision for firefighter 1, and that's again not really a voluntary demotion because, it's a firefighter 1 position, but it's a firefighter 1, it's a request of a firefighter 1 to be removed for ambulance rotation for a permanent, period, not for a temporary period of time, but for permanent. Again, that's the same reason that we, took out the other voluntary demotion proposals. It's not in the current contract. It can be requested, it can be considered, but it's not a right that was given, by the contract.
I thought this was in the.
It's an MOU.
There's an MOU in effect, and I'll send you a copy, but I thought I
If you
had.
would please
Yeah.
send that to
But-
me.
But yeah, I will. There's an
What-
MOU
Is it a
that was
recent MOU or a?
Yes.
about, hang on a second, I'll
Year
tell
and
you
a half.
exactly what
Is it the?
it was
the
a
Bishop
resolution
GO?
of
Yes.
agreement.
Yes.
Okay, it's not an MOU, but it was a settlement. My understanding of that particular settlement was that it was not intended to create a pattern and practice. Again, a settlement cannot add or take away from the contract. So what we're looking at is the contract.
Okay, well, I need to review that MOU
Okay.
and, get back to you on that.
Okay.
Okay, cause I don't,
And I don't, and I can't recall, if you don't mind sending it to me as well, so I
I'll
can look at
definitely
it
send it to
today,
you again.
if you find it, today. If it's not stated in the actual settlement agreement that it's not intended to make a past practice or intended to change the contract in any way, do you have where, that was the full intention of the city, it was reiterated again and again to the fire union, and in fact, even in drafts
Yes.
of what we were working on, it does state that.
where is this thing? Okay, Roxy, I'll send it to you.
Okay.
And let me refresh my memory on it, and then when we meet this afternoon, we can,
Okay.
we can follow up on that. Okay, so that's the city's
Right.
proposal. Let me talk about, the association, and I'll, hopefully have a counter for you on that today. And I definitely, as soon as we caucus, I'll send you the MOU, so we can both know what we're talking
Yeah,
about.
that would be helpful.
Let's talk about our proposals. Let me, I guess, talk about Article 9 first. I can get the right thing.
Yeah,
up.
mine's not pulling up. Here it is. And this is on association rights?
Yes. Response to your proposal from last week. You know, the first change, the green is language that we've agreed to.
Mm-hmm.
I think in, in C is the first area, I think, of disagreement. I want to point out to you, there's a couple of these, and I think I left them in black for that reason. But there's a couple of these where I corrected a little grammatical errors, like added an S to something or something like that, and I, didn't bother to note it because, but section C, we just want some sort of outside limit still. We've agreed to, you showed us a thing that it cost you $177 for a special assessment. I can't imagine why it would cost you more than. We looked back and we found out that special assessment provision, the $50, was put in originally in 1980. What was it, Carter? 1985, when we realized inflation has occurred since
That's
then.
right.
So we figured the 177 was a pretty good estimate, and so we put a cap above that to give you a little bit of cushion. So.
Okay. Can I just mention something really quickly
Sure.
about that, what that could kind of push that cost maybe a little? I wouldn't imagine it would go over 200 very often, but the way that it's set up is that each individual person who is, and it usually is all the members of the union, because the special assessment has to be voted on by the union, as I understand it, and it's either everybody or nobody. Each individual has the option is to pick how they're going to get that assessment taken out, as I recall. So it could either be monthly, or they could do all of it at once. So each special assessment card, I think, has a way that they can do that. So if everyone to request something very different, that could add a lot of time into inputting that stuff into the payroll system.
I'm looking at the special assessment form, and I think that we contemplate, and Carlos, stop me if I'm saying this wrong.
What page is that?
On page 59 of the contract.
Okay.
A special assessment is a one-time deal. In other words, it's when we do a special assessment, it's going to be a single assessment for an amount of X. And quite frankly, we would prefer if, rather than everybody having to submit one of these little forms, that once it's voted on by the association, it's a done deal, that the association president just notify you. I didn't make that part of our proposal because I'm trying hard not to add to the issues that are on our plate.
Okay.
But if that would make it administratively easier for you, it would certainly make it administratively easier for us. There's always, the whole purpose of dues deductions is it's always hard to get everybody. It's like herding cats.
Right.
So, if y'all would consider a thing where we can do away with these individual forms, then it's just a one-time, we make clear it's just a one-time assessment, for X amount from every association member who's given a dues deduction. We could, modify the
form.
or
Okay.
something like that.
Because I think this last special assessment that was done over a period of 26 pay periods, maybe?
I
think it was like $10 for each individual, and I'm just thinking off the top of my head, but it was a certain amount of money over a certain pay period, which requires a lot of data entry.
But it would be a uniform.
Okay.
I'm proposing a uniform thing for everybody, and
I have no objection to making it, more efficient and administratively easier for both sides.
Okay.
So, but that's just what I'm looking at, the way it currently is done. So a maximum could, may have to be a little bit higher, but we'll propose something.
Okay. Very good. On President's time off, I've gone back to kind of the status quo with one exception. We've increased the contribution from 4 to 5 hours. We did some research on the genesis of this provision, and it was added to the contract in 1990. And two things I want to say about that. That was the period that the cities were struggling to implement the Fair Labor Standards Act overtime provisions in their fire and police departments. There was a 1985 U.S. Supreme Court decision that had said that the FLSA applied for the first time to fire and police employees. And for the period of the next 5 years, there was a lot of struggle with how that was to happen. Ultimately, Congress passed a special law to show how to implement it. But at that time and in the context of that, firefighters were working a 56 average work week. And the firefighters agreed, well, two things. Number one, the chief at the time, I believe, was Adame. And Chief Adame was very intent on making the association president a full-time union person. He thought that it provided him a lot of assistance, and that's what I alluded to when we talked on Friday. The second thing is that the firefighters agreed to pay for it by doing two things. One, they would deduct the 4 hours of personal leave, and I think that they have continued at this time. But they also agreed to a reduction of their average work week from 56 to 54 hours per week as a way of defraying some of the city's overtime costs associated with implementing FLSA requirements. We have some notes that indicate that the savings to the city at that time, and of course this is now 27 years ago, was something in the neighborhood of 200 and something thousand, I think it's like $260,000 that the city was going to save via that, and that's the whole genesis of the 4 Kelly days. It started right then, and it was a trade-off so that we would, be understood only as defraying part of it through these deductions of personal leave, but the other part of it was going to be that. And so
firefighters aren't paid for Kelly days, is that right?
They're not paid for Kelly days. The whole way that a Kelly day works is that you agreed to take an unpaid day off. That's your Kelly day. And when you take that unpaid day off, it gets the city below the cap when they otherwise wouldn't be. The cap is the 53-hour work week. So in other words, they reduced partially the cap. So
were they 3 Kelly days before the 4 Kelly, or how many Kelly days did they add? Do you know?
They weren't getting any Kelly days. They were just working 24 on, 48 off, and so they agreed to 4 Kellys per year, and to knock it down to an average 54-hour work week to reduce some of that liability that the city was incurring for what we call regularly scheduled overtime. I think here you refer to it as cycle pay.
Cycle pay.
Okay, cycle pay, what you call cycle pay is regularly scheduled overtime. And the way, the average firefighter works a 56-hour work week on average, which results under the 7K schedule in automatic overtime. And so that's how that got started.
Okay.
Okay, so we do feel like that had I known all this history before, I'm not sure that I would have felt we should go from 4 to 5 hours, because I think we continue to do those Kelly days as a way of offsetting the city's overtime obligations, and that needs to be factored in. I mean, that was the deal that was made back then. I know that you're going to want to do your own research about this. I don't mind sharing with you some of the notes that we have, although I don't know how convinced you'll be by our notes from the time.
And because back in that time, I think the minutes of the session were kept by notes, and I would like to see them if you can
Okay.
PDF them and email them you know,
Yeah,
think
I won't
that's
be able to get them to
interesting.
you today.
No,
I can show them to you on my screen, but I will try and do that PDF them.
Sure, no, I understand.
Okay.
And those notes show that that particular conversation about Kelly Days, the addition of Kelly Days happened in conjunction with the president's salary?
Yes. And in fact, you know, there's a specific line that sticks in my head where they said savings to city will be $200,000 as a result of this. And that was how we were. And so I think.
And that's in regularly scheduled overtime is what you're talking about.
Right. We're taking Kelly Days, which as you know is an unpaid day off. And and that was to reduce the city's tab for regularly scheduled overtime. It didn't affect callbacks, obviously, but regularly scheduled overtime. So in other words, we started taking Kelly Days, and that reduced the city's overtime, as it continues to do today.
Okay.
The Kelly Days is a reduction in regularly scheduled overtime provision. That's why they exist.
Previous to that, all those negotiations that you'll provide the notes to me about, was the union president's position a position that was on full leave? Do you know?
No, prior to 1990, there was no provision for leave for the union president.
Okay.
That happened, and I don't know if Chief Adame is still around anywhere, but I know he went to Austin at some point for a while after that, and I lost track of him after that. But Chief Adame may be able to put some flesh on the bones for y'all too. He may, you know, we've all slept since then, but.
Okay.
Okay. I think that's the major difference between us. If you look at section 3 of our proposal.
Real quick, let me ask you, you deleted section B as to creating the vacancy.
You know, we really, it created some problems on our side. We were struggling with it, but the most important thing there is that our current president is in the entry-level rank. And so, you know, there's no requirement that you fill entry-level rank vacancies within X amount of time like there is promotional vacancies. So it really doesn't get you anything right now. It created a problem for us in that, you know, some of my team members are thinking, well, if, you know, it's a high-level person, let's say it's a captain, then that creates all this stair-step stuff, and because there's only a 1-year reinstatement list, somebody might have promoted off a list and then get demoted and not get re-promoted within a year, and we're hurting that person unavoidably. I mean, there's ways around that if y'all are interested in that provision. It won't help you now, but in the future, what we could do is make those reinstatement lists permanent or something like that.
One thing that comes off, you know, because a vacancy I think would serve everybody, one of the things is to, if you make a vacancy, to just make that vacancy a temporary firefighter 1 or something like that, like on that rank.
Yeah, you could do that.
But I gotta look at all the other implications on.
And make us a counter. It just, you know, because right now, you know, the position is in not a promotional situation. It is a situation where I don't think it benefits you as much.
Yeah.
You know, and so rather
then we
than
also
hassle
have-
with all
right.
those things that we're talking about because we got other fish to fry, I'm just doing it.
Yeah, and then I have to look at, you know, what we can authorize, but then what's really budgeted, because those are two completely different things.
So it may be, you know, a chunk we don't want to take on right now.
Okay.
But I'll, you know, wait for your counter.
Sure, I'll look to see what we can come up with.
Those are, and if we look at section 3, you know, I just added the which will not unreasonably be denied. I think that's kind of implicit in the existing contract. Educational leave is in green. And literally that's the only difference between our proposals. Look at it. I may have worded it a little bit differently, but they're substantively identical. Educational leave I put in green, but I noted that I'm using better there in the sense of like a verb to better employee
Yes.
working condition. So, and then in subsection D, I eliminated the fire chief's permission because that's not in the current contract. This is kind of an exception to that because, I mean, these conventions happen when they happen.
Okay.
And we have to be able to get off then. It's not like, you know, obviously in an emergency,
Well-
anybody can be called back to duty. I mean, that's just,
Sure.
and we would never interpret the contract in a way to prevent you from, I mean, if hurricane whatever strikes
Right.
and, you know, the city's shut down,
The
all
only-
hands on deck.
On section D, the only time we were asking for the chief's permission was when the time was to be used for attendance to seminars or training sessions. Like if they didn't use that time for attendance at the conventions, we're not saying that they need, permission for that. It's just for attendance at additional seminars or training sessions. And what we're
Yeah.
looking at was basically like something that would, you know, something that would be beneficial to both the firefighter and the department.
We'll
So-
put something in there like, you know, which will not unreasonably denied,
Sure.
and put it in your counter, and let's just
Okay.
see. Okay, and, section 7, is in black, but I think it should be in green, but I did change the wording of that last sentence.
Okay.
Just to make it read a little easier. I think I'd used the word minimize, and you said, to, will not, no, so I said to, so it'll be arranged so as to avoid interference. And so I don't think that's really a substantive difference. Okay.
Okay.
On Article 27, obviously our only disagreement is on this section 4. I thought, it may not look like I thought about this a lot because I just crossed out a bunch of stuff, but I really did think about this a lot this weekend. And here's what I came up with. You know, all of the trouble we had this past time was y'all's feeling that we violated the duty to bargain in good faith, and our feeling that we didn't. And so what I've done is I've left in the language about we won't make an effort to bypass, and we're leaving kind of ambiguous what would constitute an effort to bypass. But we're saying that whatever our duty is coterminous with the duty to bargain in good faith. And if either party feels like the other party's not bargaining in good faith, then what we do is we get together, and if need be, it doesn't even really say if need be, we get together with a mediator and try and work out our differences. And then if we can't resolve our differences through mediation, then either side doesn't just unilaterally discontinue negotiations, but you can go to court. You can go to court and seek a TRO or a temporary injunction, whatever you feel like the bargaining violation is. So you've got your full set of remedies, but the idea here is simply that we're agreeing to bargain at the table, we're trying to bargain at the table, somebody feels like that's not happening. The first thing we do is we get together and we get a mediator and we really talk about it. We don't discontinue the negotiations, but after that mediation step, either party is free to go to court or whatever, to do whatever they feel like they need to do to protect their rights, including seeking temporary relief. So I think and I hope that this won't be as big of a problem in the future because we do have this impasse procedure. But what I'm trying to do is just create a mechanism so that we can amicably resolve differences if in fact you guys feel like we're stepping over the line or vice versa. We keep talking, but
Keep the line of communication open.
yeah, because that's really kind of where I think it broke down last time. We just kind of stopped talking. So, and I think we both agree we don't want that to happen
Right.
again. And we want you to feel, I mean, I swore to you that I'd never agree to that sentence in another contract, and here it's still in here. So,
Okay.
you know what my vows were. But I'm trying to do a mechanism so that, you know, we have an ability to resolve differences. And we are, and I don't want to, you know, sell you a pig in a poke. We are understanding that we continue to disagree a little bit about what that language means, you know, but at the same time, let's not let it stand in the way of getting a contract. And so my goal there is to simplify, but to give you the assurances you need that we're serious about, you know, trying to bargain at the table.
Okay.
Okay. On overtime, I think at this point, we're really not prepared to make a counter we were asking you to reconsider our prior proposal. And I thought about this a lot this weekend too, because, you know, you and I got kind of bogged down on, well, the FLSA doesn't require us. And I kept telling you, well, the FLSA is a floor. And I thought I would make another run at this, because I didn't think that I really made my point. The FLSA really does provide a floor, and the best example of that is the FLSA itself. You know, the FLSA does two things. It sets a minimum wage, and it sets a minimum overtime benefit. But it certainly doesn't set a cap. And it's really not adequate to say, well, we're paying you more than we have to, you know, on overtime or on minimum wage. I mean, if you said to me, well, we're paying you $10 an hour, but we're going to cut that to $8 an hour, but that's not really a cut, because all the FLSA requires is $7.25 an hour. I think it's $7.45 now, but you know, but the FLSA just sets the minimum. I'm not really aware of hardly any jurisdiction, and this goes into the private sector too, where overtime benefits that have been negotiated over years aren't better than the floor that the FLSA provides. I mean, the minimum wage, to some extent, it's not a good example, simply because the minimum wage has become so irrelevant in terms of what a decent living wage is these days. But at the same time, that's all the FLSA requires. And it's, you know, the point I'm trying to make is, if we accepted your overtime proposal, according to your figures, that the firefighters on average would take a $3,000 loss of pay, even though they're working the exact same number of hours. As you pointed out to me, well, if overtime goes down as we expect, they're going to suffer that loss of pay anyway. And I agree, yes, but they're working less hours. So of course their, you know, pay is going to go down. If you work less hours, you get less pay. So I'm asking you to consider that. I understand that the city has right now an overtime problem. I think that the city has taken other steps that are going to be much more effective in addressing that with this class of 40 people that you've hired. That's going to greatly reduce the need for overtime. And I think that that makes a lot more sense than what you propose, which would be to actually a cut in pay. And I mean, you know, that's not insubstantial. I mean, to lose $3,000 in these modern times, when everything goes up, you know, is a tough pill to swallow.
How did you come up with the $3,000 again?
Well, you came up with that you would, by making this change to callback, that you would come to $1,040,000 and 40,000.
It was about $1 million.
Yeah, and I asked how many people are currently in your operations, and I think the number you came up with was 340 something. And so I just divided 340 into $1 million, and it comes out to about $3,000 per person. Okay.
I'll look at that. That's of course a generality, because the actual numbers would be.
It's going to vary from
Very
individual,
right.
but on,
There's
you
some
know,
individuals that have zero, some individuals that have more.
I know, but that makes it even more difficult, because that means that, well, firefighter A here maybe doesn't suffer any loss of pay, but firefighter B here loses $7,000 or $8,000, you know, for working the exact same number of hours.
Yeah.
And that, by the way, creates a disincentive from wanting to work overtime. And I realize that you have the ability to order people to work overtime, but, you know, that's the old carrot and stick approach.
You have to remember, you're making a comparison with minimum wage, base wage. Base wages are guaranteed. We're required to provide you compensation for any number of hours you work. And, the position requires that you work a total of 54 hours on average a week. So that's guaranteed. Overtime hours are not guaranteed. So and I know that when you work overtime, yes, you'll get time and a half, but you have to meet a threshold. You have to be entitled to overtime in order to get that. Right now, people who aren't really working overtime are getting time and a half. for hours that they're working within that 54 hours of actually working.
Well, that's not true, because remember that with regards to cycle pay, leave hours do not count as hours worked, and so you lose cycle pay. Right now, you lose cycle pay.
And that's another overtime, a scheduled overtime.
I know, but that's what you want. You know, in other words, that's scheduled overtime, and they lose their cycle pay if they take a leave. It's only when they're called back that leave hours count as hours for meeting the threshold. And so that's the only part that we're dealing with right now, okay? And so, you know, on the callback, that's, you know, somebody who's off duty and they're home with plans or whatever, and they get called back. And they're, you know, coming in on their day off, and maybe, you know, so, and you're right, because it's more or less a voluntary system right now. Some people choose to work a lot of overtime. If my kid's going to college, by God, I'll take all the overtime I can get, you know, and somebody else is not. But if you start telling them, well, we want you to come back for overtime, but we're going to pay you straight time for that because you were sick a day, then you're creating a disincentive to want to answer that call. And I'm not sure that you want to do that for the savings that you're obtaining, when I think that savings is going to occur anyway as your overtime needs greatly diminish because you're adding 40 people to the payroll. I mean, you'll lose, you know, 10 through retirement or whatever. So your net addition will only probably be about 30 or so. But at the same time, that's going to help a lot. Your overtime will come back within budget. And I think this is more or less an aberration that you're trying to address. And maybe you don't need to. So I'm just asking y'all to think about that.
Okay. All right, well, we're gonna go back and work on a couple more things. I don't know that we will, because we finished stuff on Friday, we had a lot of people out on Friday, and I know you're waiting for some, information from us, or we need some calculations in order to, for instance, the ad pay or the supplemental pay proposal, we're definitely working on that. It's just taking some background work that needs to be completed before we're prepared to present that. I don't know that we're gonna have that ready for today, since I'm only available until 2. But we will work on counter proposals to what we have here on the table today, try to move forward on those, and let's try to meet at about 1 o'clock so we can get done.
Okay.
Would that be okay?
That's fine.
So we'll
That's
work
fine.
on these counter proposals. I'll see if there's any additional information that I haven't presented to you today that's ready. I'll present that at that time also.
And let me just say this, that if you don't have the ad pay proposal done today, but you have it done before our next session, which is next Thursday, I think, the 24th is.
I think it's Wednesday.
Wednesday, is it Wednesday?
It's Wednesday.
Okay. If you have it done if you could email it to me.
Okay.
So I can give it to the team, you can officially present it.
Sure.
At the public session, but any advanced work we can do on it would be helpful.
Absolutely. Okay.
Okay?
So I'll be out of pocket Wednesday through Friday, but I will be working on it otherwise, and I'll get it to you as soon as it's prepared.
Okay.
Okay.
Very good, thank you. Are we on? One correction I need to make. I went back and looked at the notes. I conflated two things. I threw out the $265,000 figure, and there was such a figure, but it related to a separate provision on the overtime.
And we're talking about the president's time off? and
Yeah,
the
we're
notes,
talking
et
about the
cetera?
president's,
Okay.
yeah, I'm sorry. What shows, and I've got these notes, and I can show them to you after we finish here, or the better thing will be for me to take them and PDF them and send them to you,
Sure.
so you'll have a copy. But it was like, we calculated that you were gonna save 12,000 overtime hours.
Okay.
I don't know what the dollar figure on that was at that time, but, the $265,000 figure does exist, and you'll see it in the notes, but it referenced a different proposal, that we were saving you money right and left in those days.
Really? What
Just-
happened?
just
What
like-
happened?
Nothing happened, you know, we continue to.
We'd like to say.
We're just the best bang for the buck. So,
All right.
anyway,
Well,
I did want to correct that, but,
Sure.
I have the notes for you, and I'll show them to you, and there.
Okay, and I just, I gave you a heads, cause I know that we're working on a counter to that. I started working on it with what I have right now, but I'm waiting for those notes, and I'm also doing our own research to see if we can identify, any minutes that we may have taken, that would, provide some clarity to that issue. So I started working on it, but because I'm waiting for that information, I'm not prepared to present a counter proposal today. I need to look at what that says and what it
Okay.
means.
Okay.
But we are working on it. But we did do, and of course, we're also working on a couple of other things, but what I was able to do was create a counter proposal on Article 27 on that Section 4 that we've been discussing.
Mm-hmm.
And I want to talk a little bit about it because I want to tell you what I'm thinking about. On Section 4, we accepted most of the language. On the mediator, I just added a mutually agreed upon and neutral mediator. I think that's fair for both parties.
Yeah.
The sentence I did delete and I replaced is, however, neither party will unilaterally discontinue negotiations due to a claimed violation. Now, I think I know what you're saying by that, but I think it could be misconstrued to mean something else. And I added this sentence, but I have some discussion about that to let you know what I'm thinking about and where I think this should lead us to.
Okay.
The negotiation period will be suspended during the time period for mediation, and if elected, legal recourse of the alleged violation. It should probably say any legal recourse of the alleged violation. And my thought process on this is, if there's not a consequence for violating the duty to bargain in good faith, then what does it really mean? I think, of course, I don't think that any alleged violation in the time that we take in order to remedy that violation, whether it's confirmed or, whether it's sustained or overruled or whatever, I don't think that should deny or eat up the bargaining period. When I say suspended, I don't mean that those days are gonna be eaten up. I mean, it's just at a pause until we can finish, we come to an agreement on whether those are a violation or not, how we remedy it, and then continue. The other issue with continuing negotiations while this is ongoing is that it kind of creates a cloud over the negotiations. If there's no consequence to adhering to violating the duty to bargain in good faith, and then we keep bargaining, then it creates this situation where people are going to start pointing the fingers at each other anyway. And then if I allege that you were violating it and I did the mediation, but then you're pushing to set negotiation dates, and I say no, we have to figure this out if it's an ongoing violation before we can sit down and truly negotiate, then you're going to allege bad faith bargaining on my part too, because I don't want to meet while we're trying to remedy the situation. So I was trying to create
A middle ground.
And it's not to the detriment of everybody. I think it's to benefit everybody and to make the duty to bargain in good faith meaningful. And one of the things I was kind of toying with is, okay, well, obviously it's okay to be, if it's suspended during the time of mediation, that's a time certain. It's not going to take a long time. If legal recourse is elected, sometimes it can be a long time. Sometimes it can be short, but most likely it can be long. So one of the things I was toying with, well, if the legal recourse is elected, then maybe during a TRO, it would be sought as an affirmative action that we continue negotiations under certain parameters or conditions set by that court, But
that was my thinking.
But what happens if legal remedy is not undertaken, and then that was my conundrum. If legal remedies are not elected and it kind of stays at a stalemate, then where do we go from there?
Well, here's kind of how I envision it working, is that, you think we're violating the duty, or vice versa. And you say, and so we stop negotiations, we go to mediator, what should really happen here? We try to work it out, we can't. So you say, well, we still believe you're violating, so we're gonna go to court. And if you say, well, we still believe you're violating, but it's not important enough to go to court over, we just keep going.
Okay.
If you say it's important enough to us, that we're gonna go to court, litigation can take years.
Yeah.
And that's not to anybody's advantage, but, maybe it stays suspended during the time that the city needs, or it could be the association needs to, go seek temporary relief. Then you're gonna get a court saying either union back off, or union, what you're doing is okay.
Right.
Okay, so to allow you to suspend the negotiations during the time period that you need to seek temporary relief, and then we'll have guidance from the court. At least by the time, you do a temporary injunction hearing and you get a ruling on that, you kinda know.
Right.
TROs only last 10 days. In temporary injunction hearing, judge usually gives you a decision pretty quickly. And so, then you're talking about, maybe a 2-3 week hiatus in the negotiations, but not interminable. A lengthier than that's not in anybody's best interest, because by that time, city's coming up to another budget year.
That's right.
We wanna know what the contract is. But it gives you sufficient time to stop the process so you can focus on your legal remedy.
Right.
So I'm thinking that
And-
that's the
and-
kind of counter we make.
Yeah, and to stop the process so that we both protect the integrity of good faith bargaining, because the issue with just saying that we will unilaterally not discontinue it is there's no consequence to it, and there's different kinds of violations. There could be a one-time violation, somebody calls somebody that they weren't supposed to call. Or it could be an ongoing violation, something that's just, something that's out in the public, or, so there's, if it's a one-time thing, I'm sure that you could remedy that without even going to mediation and saying, hey, don't do that, or yes, we'll stop. But if it's an ongoing issue that we both disagree on, as we've previously had, I think we need to figure out a middle ground to where everybody gets the benefit of their legal recourse and remedies, and yet the negotiations still occur, but they occur under certain conditions that would maintain that integrity of good faith bargaining, and we have the direction from the court saying, okay, this is what you need to do, this is how you're gonna go about doing it.
Yeah, because we've had real disagreements about what this contract language and the duty and good faith means, and so, there's not a whole bunch of case law out there under the Texas statute, so, we don't wanna, I can easily see a lawsuit like this taking a 2 or 3 year process, but, to get guidance from the court about what the parameters are as you go on, and so you have a momentarily, I need to talk to my team about it, but I think I can make you a counter that'll get us really.
But that's where I'm heading, that's where I was heading with I couldn't figure out a way to capture it all, because if I said continue negotiations under a TRO, we're not required to, it would kind of require that somebody elect a legal, filing a lawsuit, when maybe there's instances that we don't need to file a lawsuit. We can, figure it out between that. But, so I didn't want to create that requirement I just wanted to figure out a way to ensure good faith bargaining, maintain that integrity, and provide consequences for the people who, for whoever's alleging that.
Yeah, if it's important enough to the city that they want to take a timeout and get some kind of initial input first from a mediator and then possibly from a court on where we have to go from here, then give you the timeout to do that.
And the good thing about what we have already accepted on your proposal is that it does require a mediation.
Yeah.
Which is good.
Yeah.
It opens up that communication, and most likely most of the most of the contentions can most likely be
We
resolved
greatly
at that
hope
stage.
that anything that is that important to the parties could get resolved in the mediation. Because the idea is to keep the process moving. So, okay, yeah, let us work on that, and we'll get you a counter on that.
Okay. I'm continuing to work on information that I hope to get you before the 24th in order to facilitate a productive session on that Wednesday, especially since we only have one that week. So I anticipate you'll probably be, if everything goes right, that you'll get it beforehand. I'll try my best.
And I had hoped to have, excuse me, sorry, I got to put down those. I had hoped to have for you an Article 33 proposal today, but we haven't had a chance to vet it on our team. So hopefully I'll have that to you before the next session.
Okay.
So, and I'll also hopefully have you account on this before the next session.
Okay.
So anything you can give us will be welcome, and the sooner the better, obviously, and I'll try and do likewise with you guys.
Okay.
Okay? Thank you very
All right.
much.
Thank you
Y'all have a
very
good
much.
week, and we'll see
Okay.
you next week.
Okay.